Question is directed to counsel for the President. How does the non-criminal abuse of power standard advanced by the House managers differ from maladministration, an impeachment standard rejected by the framers? Where is the line between such an abuse of power and a policy disagreement?
Thank you very much for that question, because that question, I think, hits the key to the issue that's before you today. When the framers rejected maladministration, and recall that it was introduced by Mason and rejected by Madison on the ground that it would turn our new republic into a parliamentary democracy where a prime minister, in this case a president, can be removed at the pleasure of the legislature. Remember, too, that in Britain, impeachment was not used against the prime minister. All you needed was a vote of no confidence. It was used against lower-level people. And so maladministration was introduced by Mason, and Madison said no, it would turn us. It was just too vague and too general. Now, what is maladministration? If you look it up in the dictionary and you look up synonyms, the synonyms include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Even Professor Nicholas Bowie, a Harvard professor who was in favor of impeachment, so this is an admission against interest by him. He's in favor of impeachment. He says abuse of power is the same as misconduct in office, and he says that his research leads him to conclude that a crime is required. By the way, the congressman was just completely wrong when he said, I'm the only scholar who supports this position. In the 19th century, which is much closer in time to when the framers wrote, Dean Dwight of the Columbia Law School wrote that the weight of authority, by which he meant the weight of scholarly authority and the weight of judicial authority, this is 1867, the weight of authority is in favor of requiring a crime. Justice Curtis came to the same conclusion. Others have come to a similar conclusion. You asked what happened between 1998 and the current to change my mind. What happened between the 19th century and the 20th century to change the mind of so many scholars? Let me tell you what happened. What happened is that the current president was impeached. If, in fact, President Obama or President Hillary Clinton had been impeached, the weight of current scholarship would be clearly in favor of my position, because these scholars do not pass the shoe on the other foot test. These scholars are influenced by their own bias, by their own politics, and their views should be taken with that in mind. They simply do not give objective assessments of the constitutional history. Professor Tribe suddenly had a revelation himself. At the time when Clinton was impeached, he said, oh, the law is clear. You cannot charge a president with a crime while he's the sitting president. Now we have a current president. Professor Tribe got woke. And with no apparent new research, he came to the conclusion, oh, but this president can be charged while sitting in office. That's not the kind of scholarship that should influence your decision. You can make your own decisions. Go back and read the debates, and you will see that I am right that the framers rejected vague, open-ended criteria, abuse of power, and what we had is the manager made a fundamental mistake again. She gave reasons why we have impeachment. Yes, we feared abuse of power. Yes, we feared criteria like maladministration. That was part of the reason. We feared incapacity. But none of those made it into the criteria because the framers had to strike a balance. Here are the reasons we need impeachment. Yes. Now, here are the reasons we fear giving Congress too much power. So we strike a balance. How did they strike it? Treason, a serious crime. Bribery, a serious crime. Or other high crimes and misdemeanors akin to treason and bribery. That's what the framers intended. They didn't intend to give Congress a license to decide who to impeach and who not to impeach on partisan grounds. I read you the list of 40 American presidents who have been accused of abuse of power. Should every one of them be impeached? Should every one of them have been removed from office? It's too vague a term. Reject my argument about crime. Reject it if you choose to. Do not reject my argument that abuse of power would destroy the impeachment criteria of the Constitution and turn it, in the words of one of the senators of the Johnson trial, to make every president, every member of the Senate, every member of Congress be able to define itself from within their own bosom. We heard from the other side that every senator should decide whether you need proof beyond a reasonable doubt or proof by a preponderance. Now we hear that every senator should decide what abuse of power. Thank you, Mr. Chief Justice.
President. Mr. Chief Justice.
Senator from Maryland.
Chief Justice, I have a question on behalf of Senator Markey and myself that I send to the desk for the House managers.